Thank you for joining us today. So today's program, Estate Planning Made Easy, features Cody Barbo, and I'm hoping I'm pronouncing that correct, Mr.
Yep.
Cody, who will cover the basics of estate planning, including when to update a plan and key documents everyone should know. Before I introduce our presenter, I'll mention that Senior Planet seeks out subject matter experts for these programs, many of which have used their experts in the for-profit sector. We're thrilled to have Cody here today, and he has a lot of fantastic information to share with you. We just want to note that as a nonprofit, Oats and Senior Planet from AARP does not endorse any particular platforms or products, but we do encourage all of you to take learnings from our presenters and look at the market to see what, if any, products on this topic might be good for you, might be a good fit for you. So with that, I'd like to introduce Cody Barbo, an entrepreneur and two-time founder of Dallas, Texas, and two-time founder of Dallas, Texas. Cody serves as founder / CEO of Trust and Will, a modern estate planning software startup. As a volunteer, Cody serves on the San Diego State University Alumni Board of Advisors and the Phi Kappa Theta Fraternities National Foundation Board. And at home, Cody is married, a father to a daughter. He's a dog dad like I am, and loves to cook, work out, and mentor other entrepreneurs in his spare time. So let's give a round of applause for having Cody here. Thank you so much, Cody, for being here. I'm going to go ahead and pass the floor over to you.
Yeah, my pleasure. Well, hey everyone. Happy Good Friday. Happy early Easter. Really appreciate you spending time with my colleague Craig and I. It's been an honor building our company for the last 7 years. We've helped hundreds of thousands of families, and I started this company with my business partner as I watched my last grandparent age, and she has passed, but also my own parents as they've aged and have become great grandparents. I've become a father twice over. There's my two kiddos. I got a 5-year-old daughter and a big chunky baby, and then for you pet parents, that's my dog Scooter. So that's my loves of my life, including my wife. She's my rock star. But I live here in Dallas, Texas, and we've been building this company really to help educate on the importance of estate planning. I mean, I was shocked at how expensive this process was, how time consuming it would be. And it seems so obvious that somebody would be doing this kind of like a TurboTax. You'd be able to do it easily online, affordable. If you wanted to talk to somebody, you could have support as simple as just a quick chat on a chat bot, or you could actually talk to a human. Or if you wanted to talk to an attorney like Craig, we've got a network of attorneys. And it didn't exist. And that's what we ultimately built. So our website is trustandwill.com. And Craig and I are really here today just to educate you on the estate planning basics. We'll talk a little bit about our company and what we offer, but it's mostly just to get you aware and up to date with why people should do this, what life stages and events, triggering events, get people to update their estate plan if maybe you did this 10, 20, 30 years ago. And Craig has done this for thousands of clients over his career. He now works with Trust and Will full time, and we're really grateful to have him on today. So we'll keep it really light. I think that we'll finish most of our presentation probably within 20 minutes and leave most of our time for Q&A. But I want to shout out AARP, the Oats Group. They've done a great job organizing this. We did this last year with the group out of, was it South Florida, Deidre? It was the South Florida group. But we had folks from all over the country that had participated. So I'm just really grateful for your time, willing to learn a little bit more about estate planning. So with that said, good to dive in? Thumbs up? See thumbs up. All right. Okay, let me share my screen here and we'll get started. Okay. So our company is called Trust and Will, and we've built the nation's leading estate planning platform. So think of if you've gone through this process with an attorney before, or if you've ever used TurboTax to file your taxes, we're very much like a TurboTax for estate plans. The business itself, we've been around for 7 years. We've got almost 100 people on the team. We've created over 1 million estate planning documents. So we've got a lot of experience in helping families. We have best-in-class customer support. So if you want to talk to somebody, even though you can go from start to finish in 30 minutes on your own, we've got humans available. We've got a fun little AI chatbot called Willie, but we also have attorney network in all 50 states if you really want that peace of mind, expert level guidance. And we work with some of the biggest partners in the country. We work with AARP, we work with banks, credit unions, we work with financial advisors. So we have a lot of great partnerships that bring people just like yourself to the website and to go through the same experience that we built for ourselves. So what Craig and I want to really talk to you all about today, well, what is estate planning? And you can look at it from a couple different lenses. When I started this company, I was just getting married. I was watching my parents age, my grandma age. and watching a lot of my friends deal with the same thing. Friends that were getting married, starting to have kids of their own. Calls the elder millennial. I'm closer to 40, even though I'm a younger guy with young kids at home. And I wanted something that was easy. And when we looked up all the options online, there wasn't that. We couldn't find it. I remember getting quotes for $3,000, for $5,000. And when I thought about it, I was like, well, something ever happens to me, I just want peace of mind knowing that everything's correct. It's accurate. It reflects my life, my family dynamics, the assets that I own, like my home and my financial accounts. Because if I'm not here, it'll be sad, but I want everything to transfer easily to my loved ones. So we really looked at estate planning as this multi-generational transfer of wealth. And it could be wealth of assets, but it could be wealth of knowledge. It's the traditions that I shared with my grandparents. It's the traditions that my own mom and dad shared with my brother and I are now that we share with their grandkids, my children. So when we look at the why estate planning, there's a variety of reasons as to why people do this. And we're going to go a lot more detailed in the future slides. It's first and foremost is protect loved ones, whether it's spouse or partner, adult children, or if you've got grandbabies running around. Protecting loved ones is a huge component of this. The asset transfer, most people, the largest asset they own is the home that they live in, and it's where most of your wealth is created. So being able to pass that asset down to your kids, or to even give that asset to charity, or maybe it is a home that you want to have stay in the family. You can do it through a trust and it avoids probate. It's a really amazing thing to do. We're going to talk more about each one of these in detail. For those, maybe your adult children have young kids of their own, guardianship for minors or dependents is a huge component of the estate plan. It's actually the number one reason why people start this process. Usually is they either start having kids or they're done having kids and they finally get around to doing it. Because if something happens to them, you go on a flight without the kids for the first time, having those nominated guardians is really powerful. Incapacity protection, Craig and I will talk about. So if you're incapacitated, you're either going in for surgery, you fall, get in an accident, there's opportunities to help with the decision making and the authority that you give people around medical and financial decisions. So we'll talk about that. There's also charitable intent. One of the amazing things so many families do, even with trust and will, is they leave money to charity, whether it's your local church or it's American Red Cross or the AARP Foundation, just a variety, millions of options. You can leave money to charity, to your college. It's a really powerful tool that does a lot of good. The number one thing people talk about is taxes. Taxes are very top of mind all the time. So tax control is a big one. And business succession planning. If you've got a small business or you've got family that's got a small business ownership, or you've got equity in a business, it's a huge component of the estate plan itself. And we'll talk more about that. So the next couple slides is really just this 101. I'll start off, maybe Craig, just for a quick intro for yourself, and actually I'll have you guide a couple of these slides and I'll jump back in once we get through them and we'll go from there. Sound good?
Sounds good. Hi, my name's Craig Parker. I've been an attorney for 25 years in California doing estate planning and probate. And so that's my background. I'm also a widower. I have two daughters and a granddaughter. So Cody showed off. So I'm going to show off my granddaughter there. Get to see her here for Easter. So I'm looking forward to seeing her and spending some time with her. Um, Most everybody's familiar with or more familiar with a will, and that's because wills have been around a long time and people feel more comfortable talking about those. But a will really is the opportunity for you to put in writing what you want to happen when you pass away. And it gives you an opportunity to leave different things as you itemize them to who you want to go to. And as Cody said, one of the most important things might be what happens with your children or your pets if you're not around. So, setting up a guardianship for your children is really important, and that can be done in a will. You can specify who you want to do it, because we all have those people in our lives, family members who might be the ones who step forward, but they may not be the ones that you would choose to be the guardian, right? So you don't want to leave it to just whoever's the pushiest person in the family to get in there. You want to carefully choose who you want and make sure that's taken care of. And the same with our pets. Many of us, they're like our family as well. And so thinking through who might take care of your pet if you're not here and what you would want to happen. And all that can happen in a will. Um, Wills, however, you may or may not realize, I think most people do, but wills have to go to court to be administered, and we call that court probate, in the process probate in most states. Now, if in most states, if the estate is smaller, you don't have to go through all of the formal processes of court, and it may be simple and take a few months. But for many states, as the number of deaths increase and as the cases increase, the time in court is dramatically increased. So some of you that have been through the probate process in the last few years might have had it go quickly, but now the courts are becoming backlogged. So probate can take a long time. It can also be very expensive. The purpose of probate is so that a judge can read your will, appoint the executor that you've named, and then go through the process of it's a public process in which your will is then executed or followed through. This ensures that your will is executed the way you want, that everything goes the way you want, but it can also take time and does cost money for the filing fees, the court costs, and if you involve other help through professionals, can be additional fees. But at the end of the day, what you've written and you go through court and it ends up in the hands of your beneficiaries or those who you've named. A trust. So now you've heard recently, I bet 100% of you have heard the word trust. And in the last few years, it's become more popular for people to think about doing a trust. The reason why people choose a trust over doing just a will is because they don't want to, go through that long probate process. So again, if you have a significant number of assets, if you are in a situation where you might have a minor involved that you want to leave assets to, a trust can be a good choice because a trust does not have to go to a judge or to will or go through the probate process. Instead of trust, once you set it up, you name who you want to be in charge. We call that a trustee. And that trustee can manage your assets for you. And if you leave them to somebody that's a minor or somebody who's disabled, that person can continue to manage them, which is a huge advantage. And also a nice thing about a trust is that once you set up a trust and you put your house in the trust, meaning the title of your house and any accounts or assets that you want to be part of your trust, that if you become disabled, maybe you have a stroke or you have dementia, you can have somebody take over while you're alive and help manage your trust. And that's not something you can do with a will. So that's another reason people choose it. It costs a little bit more to set up because it's a little bit more complex in that you're setting up a document that's going to start an organization that's going to start right now while you're alive, a trust, and you're going to be running that. And you can still make changes throughout your lifetime. But now you have something in place that will avoid going to court and will also provide for your loved ones and yourself in the situation where you might become sick or need that. So several kinds of trusts. So there's what's called a revocable trust, which is the most common. This is the type of trust that you can make changes. We sometimes call it a living trust because you can make changes as long as you're alive. And that means that you can change your beneficiaries, you can change who you want to get what, as long as you still are alive and you still have your mental capacity to be able to do it, you can make changes. Another type of trust is called a testamentary trust. That's a trust that you can put in your will, but it does not come into existence or doesn't start until after you die. So unlike a living trust that starts while you're alive, a testamentary trust starts after you're deceased. Typically, those are set up for minors. So as you can imagine, you can't leave a house to a minor. They can't have it in their name legally. So you would have to put it in trust until they become an adult. Or if you want to leave them any kind of large sum of money and they're still minors, you need to have an adult manage that. So a testamentary trust could work for that situation, and you can do that in a will is where that gets set up. However, with a testamentary trust, you are still going through probate and you are still involving a court. Whereas with a revocable living trust, you can avoid court. Then you have tax planning. So tax planning may be useful, and trust can help with that. Right now, um, everybody in the United States can currently, as far as the federal law goes, they can give, each individual can give up to $14 million without being taxed. So that has gradually gone up, or has jumped up, I would say, not gradually, but over the last few years has jumped up, that exemption. And so many people don't find that to be as big an issue as far as tax issues as they used to be. But in the past, it used to be lower. And now we've got this huge exemption that we can take advantage of. A trust can help if you are in that situation with allowing you to maximize your gifts, typically if you're married, so that you can get more gifts to your children. Special needs trusts. These types of trusts are set up, as I mentioned before, if you have somebody that you'd like to leave a gift to, but that person might be disabled either physically or mentally or both, then you can set up a special needs trust. Those individuals often are receiving public benefits, and a special needs trust will not prevent them or terminate their benefits. So it's really wonderful. It's a way for you to name somebody to manage the money for them. And just like the name implies, you can provide special things for them that maybe Social Security or Medicaid is not providing for them. So that's a fourth type. When should you consider trust? Like we talked about, particularly if you want to leave a lot of assets to maybe somebody who's a minor, a children. Also, if you're in a blended family situation, trust can be a way for you to handle that problem. And then also there is a privacy issue, because when you have a will, it's going to go to court and that's going to become a public document. So you might see that a lot of celebrities or people might choose to keep their life private, and they do that by creating a trust, because the trust never becomes a public document for the most part, of course, unless there's some kind of conflict. But for the most part, you're able to keep your life a little bit more private. And then, of course, when you have a lot of assets, a trust can help manage those assets while you're alive, as well as after you pass. And so the more assets and the more complexity, then often people might choose a trust to help manage that. So trusts, unlike a will where you just list what you want to go to who, with a trust, you actually have to change the title to an asset. So like I talked about, we call that funding. So after you do the document, which is the will, and you choose somebody to be in charge, which we call a trustee, and that person might be yourself right now, but you can name people to take over and be in charge, which we call successor trustees, or somebody who's going to take over. But you need to fund the trust. You need to put things in the name of the trust. So often you will you'll transfer, for instance, bank accounts, and instead of them being in your name, they're going to be the name of your trust. And you're going to work with your bank on doing that. Retirement accounts, often you will leave in your own name because of the tax consequences. We know that we've got tax deferred money in those type of accounts, and you can name beneficiaries. But if you have a trust, you can name the one of your beneficiaries could be the trust, and that could be useful. With a house, real estate, land, apartments, any real property, all of that can be deeded to your trust, and that way it does not have to go through a judge and through a court to be transferred to the people that you want upon your death. And it makes it easier for them to manage it if they're having to collect rent, so forth. There's no delay in between your passing and them taking over the assets and being able to collect them. And finally, if you have businesses, you're able to transfer the interest of the business. For instance, let's say it's a uh, limited liability company. You can transfer the membership interest that you might have in that to your trust. That's the way that when you pass, then whoever you've named to take over that interest can have it. So there's ways that you can set up your business and transfer it through a trust mechanism, but you need to fund it to the trust. So wills and trusts, um, they're both very important tools. I would not say that one is better than the other. What I would say is they can serve you better depending on your circumstances. So wills are better in the sense that they're simpler, so they're less expensive, more straightforward to set up, and may not need that. Trusts, on the other hand, are going to be a little bit more complex. The key features of the will is that you're able to name guardians, you're able to say who you want to get what. With a trust, you're able to hold your assets while you're alive in a trust, which can help protect them and give you the opportunity to have somebody help you with those as you get older or as you're unable to do it yourself. Um, with a will, it has to go to court, so you lose control in the sense that it's going to go through a legal process, and you're subject to that process. With a trust, you keep control. The process is outside of court. So with a will, you're going to go through probate. With a trust, you're not. You'll also save on the costs on the administrative side, typically if you don't have to go through court. Okay. And then as far as timing, the process when you pass away with a will, it can take longer. Again, it's taking longer all the time because of the court process, whereas with a trust, that can be shorter. I would say a will can serve people well if they have limited assets. Maybe they're younger. Maybe they are just wanting to take care of their children, those types of things. As they get older, as they acquire more assets, then they might want to think about more of a trust. So here you have a little at a glance concepts that you could look at that help you think about making decisions. By the way, when you set up a trust, you will still have a will, but the will is what we call a pour over will, which means it won't say who gets what. It's just going to say that everything you own is going to be part of your trust. And that's to make sure that if there's any assets outside your trust, that when you pass away, they get into your trust. So some important documents. As part of complete estate plan, you want not only a will and or a will and a trust, but you also want to consider your health decisions. So an advanced healthcare directive is critical. It's a document that allows you to name somebody to talk with the doctors and make health decisions if you're unconscious, if you're unable to communicate with your doctor, maybe a severe stroke or other situation. Many of you may have gone down to the hospital and they have you fill out paperwork before you go in for a major operation or surgery. But what about if you're brought in on an emergency basis and you're not able to fill that paperwork out? This is something that would cover you in any situation so that you don't leave yourself in a situation where the doctor has no one to communicate with. If you do, your family or friends would have to go to court and get a judge's permission, and that process is expensive and lengthy. So in this document, you name an agent, you also name and can put in there what you want that person to do. If you're in an irreversible condition or you don't get better, give some guidance to that person as to what you want to happen. The other is a power of attorney. That's to allow people to do financial decisions on your behalf if you become unable to do them. And again, that could be directing your Social Security, collecting disability, dealing with veterans benefits, all those things. Even if you have a trust in place, somebody's going to have legal authority to deal with your financial matters, and that can include things outside the trust. So very important document to have. And even for a young person, you never know when you're in an accident or when you need help. and your friends and family will want to help you, and they won't be able to help you without these documents. So everybody over 18, really 18 years old, need these documents and a healthcare directive and power of attorney. And they're very economical, they're fairly simple to do, and very available. But they're part of a complete plan when you're thinking about wills and trusts.
Okay, great. I'm going to skip these two on digital assets for time, but I'll have you chat with this one and then I'll take back over.
Okay, so as we talked about I mentioned earlier taxes, people tend to worry about a death, inheritance, or estate tax. Currently, there's very few people that need to worry about it. That's the good news. So right now, actually the limit is 14 million per person, so you could do $28 million. Now that is set to sunset and come back. So beginning of January 2026, it's going to drop approximately in half. So 7 million or 14 million as a couple. However, depending on what Congress does, Congress could get together and act before January, and they could decide to keep it at the current level of 14 million each. There's even a discussion in Congress to do away with this tax altogether. And in the current climate, that could happen. So, in my 25 years practicing this, when we first started back in 2000, the limit was 650,000, and a lot of people were affected by that. I saw it jump to 1 million to 5 million. We had 1 year where we had a majority in Congress who decided to do away with the tax. And for 1 year, we had no estate tax, no matter how much you had. Then it sunsetted and they couldn't agree to keep it in place, but we kept in place these high numbers, and then they indexed them. So every year right now they're going up, based on an index, so that with inflation it goes up. So right now the limits are very high, um, and all we can do is guess as to what Congress will do. But I think there's not very much concern with most people thinking those are going to come down anytime soon now. They're probably still going to stay high. The reason that's important is for you to know that you probably are not facing those types of challenges. Now, there are also in each state, some states there's a limited number of states, about 10 of them, that have some estate tax in your state as well. So you'll want to look at that. But for the most part, if you do, you should talk to professionals, your CPAs, attorneys, to help you do some planning there.
Awesome. Thank you, Craig. I'm going to skip to just a quick slide on getting started, and then I'm going to walk through some life stage events, and then we'll go ahead and kind of open it up to the audience here. But I appreciate it. We got such a great attendance today. Over 170 of you hopped on. So getting started, it's very straightforward. It's basic information. Starts with you, spouse, kids' legal names, birthdays. If you do have minor children or even pets, for all you pet parents out there, who would you choose to watch your children or pets if you were to pass away? Yeah, for executor and trustee, who do you want to nominate as an executor or trustee, as a person responsible for carrying out the wishes of your plan or managing the trust if you set up the trust? Assets and distribution, how would you like all your assets to be distributed? What percentages to whom? You could divide it up. Very common for people to divide it up evenly amongst their children. Or if you've got a favorite child and a falling out with another child, you can distribute it however you'd like. And you can include specific details as reference to your executors too. So you have financial institutions, you have accounts with real estate addresses, you might have specific wishes around family heirlooms, might be art, collectibles, all the way down to, as Craig discussed, business ownership, whether it's an LLC, C Corp, et cetera. The thing that we really try to do well at Trustimo, it's what we're known for, is make this as approachable as possible. So one of the things people like about meeting with attorneys like Craig is that you get the trusted relationship, you get the expert guidance, you have a real human that you can interface with. And even though we are a digital brand like a TurboTax, we have humans standing by, we have the attorney network, but we designed the platform in a way that feels very human centric. It's one question per screen. We start with a simple quiz before you decide whether you need a will package or a trust package. And generally, most people come through our website. They'll spend about 30 to 45 minutes with us, whether they chat in or not, that's up to them, or they want to speak to an attorney. And what I love about our platform, because I'm a customer as well, is that as my life has changed, I moved from California to Texas. We bought our first home. We've had 2 kids. I started a company. I can log back in and make those updates really easily, really affordably. And that's something that we'll talk about at the end of the presentation is when to do this and updates. But maybe at no surprise, like the life stages, I know the audience here today, but a lot of you have extended families, you have kids, maybe grandchildren, you've got neighbors, best friends whose kids are becoming adults and going off to college or becoming married for the first time. So all of these events have nuance to it. Getting married is an obvious one. Some people do get married. I have friends' parents who are getting remarried now in their 60s and 70s. Is there any plan in place already? So creating or updating the estate plan is top of mind. You have a lot of decisions to consider. It's not just yourself anymore. It's you and somebody else. I thought my wife and I were going to be aligned on our estate plan. I thought cremation was obvious and forward thinking. And when we decided our final arrangements, my wife's like, nope, you're getting buried in the ground next to me. So I said, yes, ma'am, and listened on. Prenups are becoming more popular than ever. There's funny enough, there's a company like Trust-A-Mall that does prenups online, helps families do prenups as they get married. So prenuptial agreements are very popular. Kids is still the biggest trigger. Craig and I have mentioned this multiple times. If this maybe even prompted your own estate plan for the first time, there's a lot of decisions to consider, but really it's the importance of legal guardian, best practices. We educate on best practices of nominating a legal guardian. It's really important to have this conversation with those who you choose. In my world, like my siblings, my brother and sister-in-law, my brother-in-law are phenomenal people. When we had our daughter 5 years ago, they weren't quite responsible. Maturity levels weren't quite there. So we stuck with our parents and my in-laws. But now as my brother has become a father himself, he's got stable income, same with my sister-in-law and brother-in-law. It's really easy to swap those over time. So a lot of people can change those as they please. Children going off to college. We actually just launched a young adult plan. You have 2 to 3 million kids going off to college every year. And as Craig pointed out, yes, they're your son or daughter, but when they turn 18, they're an adult, legal adult, and you need some of those healthcare docs or the healthcare proxies in order to make decisions on their behalf. So setting up the POA and HIP authorization is really important, and having the conversation with your children. It's kind of an uncomfortable topic to bring up, but it's one of the most important conversations you can have. And we've got a lot of great education around this specifically. So outside of family dynamics, buying a home is often, like we've discussed, the biggest asset that a family will own. You might own it and live in it your entire life, or it might be a starter home to a bigger home so you can raise your kids, grow your family, and then kids move out of the house. Now you're downsizing because you don't need all the extra space. All of those are triggers to, again, create or update the estate plan. And if you do set up a trust, to put the home in that trust, retitle it. Getting divorced, it's uncomfortable, but it's super common in this country. It's kind of, I want to say taboo, but it's culturally acceptable at this point. So getting divorced, what considerations needed to take if there was an existing will or trust with the family that now needs to be updated as individuals, or if you then get remarried, how do you think through the blended family dynamics? We have a lot of great education on this at Trust-A-Mall. And there's really the decisions around the kids primarily and the assets or the pets. I know for some of my friends who've gotten divorced, pets are actually the biggest contention. So I put a dog on the slide. So when to update your estate plan? If you've done this before, I don't know if anyone's gone through this process, whether it was with an attorney or a LegalZoom, or you did it through another provider. Life changes. And a lot of folks, I don't know if you've done this, they forget about when did I do it? Why did I do it? What's in the estate plan? Where is it physically located? Is it in the box in the closet, the attic, the garage? I was prompted when we started the company to go ask my mom and dad. This is 7 years ago. So dad at the time was early 70s, mom was early 60s. And I'm the oldest of 2 siblings. I said, Mom and Dad, I'm thinking about starting this business. Why have you never brought up your estate plan with Ty and I? thought we were cut out of it. I was asking this question. But my mom, she goes into the garage, she gets a box. In that box, it's a 3-ring binder, something that looked like an old college binder for me or my brother. And I'm reading through it, and I could tell it was out of date because I was 28 years old at the time, and it was written as if I was still a minor, with my aunt and uncle being in there mentioned a lot. So as I'm going through this, my questions I asked my mom and dad was like, is your attorney still practicing? Have you considered updating it before? And why haven't you brought up the conversation with Ty, my brother Ty and I? And he took all these, like, well, life gets busy, we're retiring and downsizing, all this stuff. But I think that the real emphasis I'm trying to use here in my own personal example is if you've done this before, When do you update it? Reviewing it every couple of years is such an easy thing to do. Whether you have the physical copy or with Trustimonial, it's as simple as logging back into your account. You can see all the decisions you've made. If you've gone through a major life event, you've lost someone in your life, a divorce, health scare, or the more positives, you've watched your kids grow up and turn to adults, or they're getting married, they're starting to have grandbabies for you. Great opportunity to review the estate plan. My brother and I yell at my mom never like, give everything to the grandkids. We're good. Just leave it all to them, set them up for success. Moving states. I moved from California to Texas. You have a huge migration happening more than ever in this country of people moving states. It's a great way to update the estate plan. Substantial changes in net worth, whether it's you receive an inheritance, you hit a lottery jackpot, something good happens. That's a big reason. Selling a home, big change in net worth for some folks that home's been in the family for decades. And family changes, which we've mostly covered. So there's no life event that's off the table here. There's millions and millions of people going through these life events every single year. And at Trust and Mo, we just want to make it aware and easy and affordable for people, again, to create the estate plan or to update it. So I guess in close, I think that's my last slide in the presentation here. Let me stop my screen share. Craig and I are here. We wanted to do this today just to be a resource. If this is your first time hearing about estate planning, thank you for listening to us for the last half hour. If you knew a little bit because you've gone through this process before, hopefully a nice refresher course. And whether you choose to create a estate plan with us or update with us, there's no pressure here whatsoever. It's really to prompt you to do it. If you've got a great attorney, go catch up with them. If you've done it with another provider, go take a look what's in your documents. And Craig, if you have any closing words, I think we can open it up to questions, but I'll pass it to you first before we do that.
Yeah, I always like to say that estate planning really is, we think of it as about stuff, like our money and our stuff. But really, it's about people. It's about the people that mean the most around you, and it's about making it easier for them. It's really a great gift that you're giving to them. When you name somebody as your to take care of your health care, and you do a health care document, it's going to be so much easier for your family and friends to help you when you need it. And you know they're going to come and want to help, but if they don't have the tools, you haven't provided them the tools, they can't do it. And the same when you pass away, you don't want to leave people with burdens or with messes. You want to leave them in the best situation you can. So really, it's about helping those around you, and it's really important to think about that. It's not so much about who's going to get what, as it is about maybe leaving behind a legacy of care and of wanting your family to get along and so forth, friends.
Thanks, Craig. So back to the senior planning team, and we've got a lot of questions here in the chat. Craig, thank you for answering those while I was going through. Would it make the most sense that we kind of go top down, Craig, the ones that we didn't get a chance to answer, and we can just kind of dive through these, or the senior planning team will rely on you for guidance here?
Sure, yeah. I mean, I can repeat some of the questions if unless you guys want to scroll through. The first one that I see came in a little bit earlier when we first started, from Connie Alvarado. What if the home listed in a will is sold before death of the owner?
So I can answer that. So just because you put in your will that you want something to go to that person, if you then sell it or you make even gift it to someone else before you die, then there's a principle of law just called lapsing. All that means is that it doesn't exist, and so it can't be gifted to them in the will. So you don't have to worry about that. If you change your mind, if you sell it or you gift it, you can do that. Obviously, it would be great if you update your will, but you're asking if it wasn't updated and you had already gifted that to someone else or sold it, then that won't change, as far as it'll just be ignored what's in the will.
I'm seeing this question's asked a couple times, Craig. It's about transfer on death, TOD, for homes and title.
Yeah, that's a newer concept. Some states are doing that, where you can do a deed now, right? And you can say on your death who you want that real property to go to. And it's a very economical and could serve a good tool, good good tool to use, and for many people. One thing to consider though is to think about is that, let's say you right now you're thinking, okay, it's simple. I'll leave that to my daughter. And so you go down and you do that, but realize that if your daughter passes away before you, or you're in an accident with your daughter, that deed won't serve that problem, right? So it works really well as long as that person survives you, and it's really simple and it's cost effective. But sometimes that doesn't happen. So sometimes having a trust that says what happens if somebody dies, then you have an alternate. You have a place for that house to go, if that makes sense. Whereas a trust, doing a deed can be limiting. But I'm not saying it's not a good tool, and it may be the right tool for your situation, but you also want to consider those types of things in your planning.
Yeah.
And realize, like, you can't leave it to a minor, right? So if you envision that ever going to any minors or things like that, you can't use that tool.
That's helpful. This one I can take. Do you have to pay yearly when setting up a trust? Whether you go with an attorney or if you go with Trust Mill, you're generally paying an upfront fee. So with us, it's a couple $100. Try to make it really easy on the wallet. That was a really important thing was when we started the company, is make this more affordable, more accessible. Most attorneys charge a couple $1,000s to set up a trust. You're not required to pay ongoing maintenance, but attorneys have billable hours. Those updates may be in the hundreds to $1,000 range typically. And then at Trustamil, it's an opt-in. It's not required or forced on you. You have the choice. We have a small annual subscription. It's $19 a year for the will. Everything's stored digitally, securely. You can come back and make updates to it. And then for the trust, it's $39 a year. We try to make it really low cost because people aren't updating it, and hopefully not updating every week or every month. But as those life event happens, an annual check-in is something that we proactively do with our members, as we'll reach out to them, say, hey, Craig, has anything changed in the last year? Just do kind of like an audit effectively. And we have a really cool feature in Trustamil that we call plan strength. And you can think of plan strength kind of like a credit score for your estate plan. We take all the data that you've put in there and try to bring awareness to areas that have gaps or opportunities. So the biggest gap being most people don't get around to executing their documents with signature notary witnesses. That's one of the most important things. Or if it's the trust and you haven't retitled the assets like the home or the financial accounts, we really try to nudge the customer to do those things. We have a little game plan to help with that. So, and we have a whole trust funding guide. That was an easy one. Let's see here. This one we kind of talked about, Craig, but the difference between a trust and a power of attorney, just to re-click on the POA docs versus what the trust function is.
Yeah, so the concept is that your trust, remember, is only going to manage what you have titled in the trust. So as an example, if you have a bank account and you have actually on the title to the bank account, on the statement, it says your trust name at the top of it, then your trustee can control that account that you've named. But if there's an account with your name on it only, then the power of attorney, you would need a power of attorney to control that account. And so the power of attorney might come in more, even if you do a trust plan and you put everything in your trust that you can think of, you still need a power of attorney because often you're dealing with, like I said, if you deal with Social Security, that's something that's coming in and you can't, it's not yet in your trust, or you're dealing with any government agencies or things that you have not yet collected. So your power of attorney is going to deal with all that. They can hire professionals on your behalf, like attorneys, if you're in an accident. So having a power of attorney is a very important document, and it's separate from doing a trust. So I hope that helps. They do overlap some, as you see, but they're very different because the power of attorney has no control over your trust or your trust assets, and your trustee has no control over anything outside the trust.
We've got a question here. We sort of answered on the different types of trusts, but the difference between a revocable and irrevocable trust. I think a lot of folks here have heard that term before, revocable and irrevocable. So we can revisit that one real quick.
Yeah, so revocable means you can make changes, and irrevocable means you can't. So you would say, well, why would anybody choose that? I would hope you'd say that. Or it might sound good, like you don't. I guess some people would say, oh, I don't want it changed. Well, you might have something happen and you do want it changed. So it's the most favorable place to be is be able to change it. So why would somebody choose irrevocability? The only reason why you would do an irrevocable trust would be two, really, two main reasons that people do it, maybe three. The first one that most people think of or do is because it's for a tax reason. So if you're in that high bracket, if you're part of the 1% in the United States, then you're using irrevocability because you're making a current gift and you're getting it out. But again, there's a huge offset to that because you can't change your mind. Okay. So it's typically just so you can avoid a tax. The second reason somebody might do it is because they're trying to avoid a creditor. Somebody owes you money. So again, the concept is I don't own it anymore, but there's some danger because you don't own it anymore. So you got to make sure it's not something you really need. So irrevocable trust can be very tricky, and you want to make sure that you get really good advice because you can't just change your mind once you do that. Revocable trust is where most of your benefit is going to be from. Most people, that's what they need. If you're going to go into start doing irrevocable trust, you need to really get some good advice because you can get yourself into a situation where you create something that may have a lot of consequences that you didn't want. Because you really are making a present gift. And there's all kinds of tax consequences that come into play and other issues. The last one that I can think of a reason, sometimes you use irrevocability when you have blended families. And the reason why is because if you are concerned about conflict, where you want to make sure that when you die, that your children, then you don't want that spouse to be able to change any of those gifts, or you're concerned that they might do that, then you might consider an irrevocable type of a trust because it might protect the children that you don't share with the spouse. So if you're in those types of situations, I think the 1% is a very small number of people obviously need it for tax purposes. If you have a lot of creditor issues, then you really want to think that through. But again, usually that's people that have a lot of assets. They might try to hide them offshore, all kinds of things. The third one is more common, right? So you need to consider the conflicts that could arise because of the combining of families and who your beneficiaries are, and how your relationship works with your spouse and ways that you can do that. But if you have to, you might have to do an irrevocable trust. The reason I say have to is because with that is going to come some consequences, tax issues, other things, administrative costs that are an addition that you wouldn't have with a revocable trust. So that's my shortest way of giving you that. And I would say for most people, a revocable trust is what they want.
Yeah. I'm answering, that's super helpful, Craig. For a lot of the chats in here, I'm adding links from our resource center. We have a Learn Center with hundreds of articles on a lot of the questions that you're asking here. They're updated frequently with best in class education knowledge. It's folks like Craig and our attorney network that are oftentimes filling that out. And if we miss a couple of these, please forgive us. You can always reach out to us directly on the website. There's one in here that I thought was interesting, and this might apply to more than a few of you. Craig, you want to talk about international property? A lot of folks, they either move to another country or they have property in another country. And this is very common. So maybe just a quick highlight on this piece.
Yeah, so you can imagine if you do have when you talk about, I guess, international property, I'm envisioning like real property, like a house, right? Or
Yeah.
if you're talking about houses or land, then you really need to you realize that's going to be a little bit more complex, right? Because now we're dealing with laws of two different total countries. All right. So you can imagine that countries want to control their land. So you're not going to easily be able to do that just in the United States with what you decide happens. Whenever I have clients or people that had international assets, I had many that had stuff in Mexico because we're very close to Mexico, right? and people that owned property there. It's complex in Mexico. Those that do own property, you know that many parts of Mexico, a U.S. citizen doesn't actually own that, right? They own part of a corporation or a business or other entity that then owns the land. So it's very complex. What do I advise? I advise that you have an attorney or professional, or you do a estate planning in that country. So you want to get advice from somebody, whichever country that's in. What's the best way to deal with that, especially if it's real property, meaning land or houses? You need to make sure that you get that governed that way. That being said, we do have what's called the Hague Convention, which just means that every country is supposed to try to honor the wills and so forth of another country, and laws of other countries. So I have gone to other countries with wills and tried to get those processed, and they do. But when you do go through that, they may interpret your will in a way that you didn't intend. So that's why, again, it's good to get good advice in the other country. That's what I would do. And it's other people I know have some things in Canada. Same thing. You'd want to get advice from somebody in Canada if you had that. If it's personal property, meaning not land, not tied to the land, if it's bank accounts or other things, those are easier to deal with. That you can handle with your will or trust. You can do things to then collect those assets much easier. But when you're talking about real property, you'll need to think about that business interests. You're going to end up doing documents in those countries if you want it to go smoothly.
I thought this was an interesting one. If you have no surviving family available, who makes the decisions on your assets and how are they allocated? That's an interesting one.
So, two ways to answer that question. I'm not sure if you're saying, hey, if I do nothing and I don't have any family, what happens? So if you do no estate planning and you do none at all, which is the majority right now, most adults, so 70% of our country happens every day. So they do no document, no will, nothing. What happens? What happens when you pass away with your house and your land and your property that you own is that somebody comes forward, and then your case, you're saying, yeah, but no family will come. There's government appointees. So, like in most of the United States, they call them public administrators, and they're elected officials. And the way they get tipped off is because the hospital or the morgue or wherever will want to be paid. These get referred to them, and I represented, for instance, the San Bernardino County Public Administrator's Office. And so they would step in, but you go through a whole probate process. And now you want to know who gets your stuff because you have no family, right? Well, first, your debts would be paid that you can imagine. And then, believe it or not, just like they say, there will be distant relatives that will be found. In all those cases that I had, they'd be people you don't even know, people sometimes in other countries that are distant relatives. There are companies that just go out and try to find them. They then get a part of a recovery fee, for finding those people. They sign them up. But I'm giving you real life. That's where it goes. Now, if you're talking about what happens, how do you choose somebody to be in charge if you have no family? If you want to do a document like a trust or a will, and you feel like you don't have anybody that you could choose to serve as the executor or trustee, because there were some questions about that. If you're in that situation, that's okay. There are professionals that will act as the trustee or your executor and take care of it for you. You can go and interview people, and there's also companies that will do that, trust companies. A lot of times the trust companies have asset limits. Banks and trust companies often are talking in the millions. But there's also individuals that will help. So you can reach out in your area. They're called professional fiduciaries. You can interview some of those people. They're even willing to act like as your healthcare directive while you're alive, or help you as a power of attorney. If you don't have people around you that you trust, these are going to be bonded people who are professionals. I hope that helps. They are,
Yeah.
of course, going to they're going to be paid, right? So they're going to charge. Most of them are going to charge by the hour or whatever. So those are questions that you can ask. But if you didn't have anybody, and by the way, it's an ongoing thing. We recently had a survey that we did, and a lot of people would like to choose a neutral person because even if you do have kids, sometimes you're like, I don't want the conflict or the family or the friends. So maybe you want a neutral person. That's something that is available under the law. There's people that act that way. There's companies, and our company even is thinking about helping in that way if we can. So those are legal options, and people do choose them.
Yeah. Thank you, Craig. I know we're coming up on time here. I just want to say thank you to everyone again. If you have any other questions, please reach out to trustable.com. We've got our support team. You can let them know that you spoke to Cody and Craig. They'll take great care of you. And just want to say thanks again to the Senior Planet AARP folks for inviting us and for the opportunity.
Yeah, absolutely. Thank you so much, Cody and Craig. Let's give Cody and Craig a round of applause. Great presentation. I think we got a lot of great advice, a lot of great questions answered.